Presented by First Commonwealth Bank here at AM 1160 WCCS 101.1 FM. Marshall Chriswell is in the studio with us this morning. Of course, the segment is called Martial Law, and this segment is not intended by us to be for anything other than informational purposes. It does not constitute legal advice. The law constantly changes. The information may not be complete or correct depending on the date, your particular legal problem. Each problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of that, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Marshall Chriswell is one of those, and he's right across the studio from us here, the microphone. Good morning.
Good morning.
It's interesting, you know, when you read that disclaimer, what really popped into my head was our topic for today. I would guess that the laws that govern trusts are pretty specific to different states or regions. Would that be the case, or are they pretty well general rule? As a general rule, are they pretty well standard?
When you're talking about trusts, there is some variation from state to state. Of course, I only practice here in Pennsylvania. Excuse me. But most states have adopted the Uniform Trust Act. Mm-hmm. So that's a uniform law that was developed. It's been adopted by, I would say, certainly a majority of the states. So there is some consistency from state to state when it comes to how trusts are drafted, what they can be used for, and how they're enforced.
Okay, well, let's talk about trusts, what they are, how they function, and who benefits from them. You were telling me you could even set up a trust for your pet.
Yeah, that's right. Yeah. So a trust at its most basic is an agreement. It's a document put in place by the client, who is generally referred to as the grantor, or less often referred to as the settlor. And the client puts in place an arrangement where another person, known as the trustee, holds property and manages property for the benefit of a third party, which is a beneficiary.
Okay, so you've got three parties involved here.
That's right. That's right. And it only takes one party to create the trust, just the grantor. The grantor could create the trust without the knowledge or consent of the trustee or the beneficiary, but it's not the best idea in the world.
Sure.
The trust, so that's at its most basic, and it's a very simple concept, and it's what you think of, when you think of, I think the colloquial term would be a trust fund baby, somebody that is living off of a trust fund. Well, that person is the beneficiary of a trust that was set up probably by a parent or a grandparent, and it's being passed through a bank or an attorney or somebody else appointed as a trustee. So that's kind of how generally in our culture we think about trusts. But trusts can be used for all kinds of things. And it's ever evolving, and it's only really limited by how creative the lawyer can be that's drafting it. Mm-hmm. Trusts can be used to avoid a big reason for purpose for trusts is to avoid certain kinds of estate taxes. Okay. Put it in place as part of an estate plan to avoid federal estate taxes if your estate it has potential to be liable for those. Excuse me. There are trusts that are put in place to, like you said, for the benefit of not even a person, the benefit of an animal. Mm-hmm. And we actually have a law in Pennsylvania that provides for what we call pet trusts.
How about that?
Yeah. So it's really an interesting area of the law. The pet trusts, and it's a pretty new concept because, I think just culturally, pets are becoming more like family members all the time. Mm-hmm. And people think of their pets as family members, and I don't know how true that was 100 years ago. So this is kind of an evolving area of the law where you can put a trust in place, you can appoint a trustee that takes over in the event that you become incapacitated or that you pass away, and this person is tasked with and is obligated to care for your pet. and this would be a trust that it would be funded, meaning that you would, at the time you create the trust, you would identify a source of funds by either setting aside a separate bank account, a life insurance policy, or even an investment account or something like that, that would be solely for the purpose or partially for the purpose of benefiting this your pet. And so that those funds would be available to the trustee.
Now, in terms of not pets, but people, we set up a trust. Tell me about when does the trust actually kick in and start providing funds? Does it necessarily have to be when someone becomes incapacitated or passes away, or can it be on a certain date when the beneficiary turns a certain age, they begin to receive money from a trust? How is that all worked out?
Yeah, it's very flexible. So it could be either of those. Most of the time, most trusts are trusts that are payable after the death of the grantor, of the person creating the trust, and most of the trusts that are out there, most of the trusts that are created are estate planning trusts, and generally those are what are referred to as a living trust. Okay, so those are trusts that are created by the grantor for purposes of passing wealth to the next generation, or any other beneficiaries efficiently, and those trusts are revocable, meaning that the grantor has the ability and the legal right to change those at any time during their life. So that's a revocable living trust, and those are an important estate planning tool. Other trusts are irrevocable, meaning that the person creating them, the grantor, is not able to make any changes to the trust once it's drafted and signed. So those types of trusts are put in place generally for tax avoidance, and there are laws that say, okay, if you're going to put money into a trust that's not going to be counted as part of your estate for tax purposes, then the consequence is that money is in the trust permanently for the benefit of the beneficiaries, and you cannot go back, even if you need that money, you can't go back in and touch it.
Marshall Chriswell with us. The segment is called Martial Law. We're talking about trusts today. In particular, who are the people who would be most commonly recommended to set up a trust? What I'm getting at is it seems on the face of it as if you must have a certain rather high level of income or wealth in order to set up a trust. That's not really the case, though, is it?
No, that's not true at all. I've set up. It's interesting. You brought up the pet trust, because that's one that I've done quite a few pet trusts, and those are we often think of. Did you ever hear of Leona Helmsley,
Sure.
the Queen of Mean? She set up a $12 million pet trust for her little. I don't know what it was.
Her mean little dog,
a Bichon Frise or whatever. but yeah. So that's what people think of. But I've done pet trusts for folks certainly of more modest means, more middle-class folks that just want to make sure that their pets are cared for, and have those arrangements in place. So those kinds of trusts, and also living trusts, estate planning trusts, those can be a very important estate planning tool for middle-class families. It just depends on the circumstances. If you own property outside of Pennsylvania, and a lot of folks who aren't extremely wealthy may have a condo, have an investment property somewhere, or a camp property that is not in Pennsylvania, a trust is an important tool to streamline estate administration when you pass away. So that's one example of a good use of a trust that you're not necessarily talking about just extremely wealthy folks.
So somebody out there is listening to this morning. They're saying, well, I have a will. Why would I? What's the difference between me setting up my will and me setting up a trust?
And a trust isn't always the better solution, but the difference is You can streamline the administration of the estate. Generally, the beneficiaries can access the funds more quickly. Nothing has to be filed if the estate is set up properly and administered properly. Nothing has to be filed at the courthouse. You don't have to open an estate, have it published in the newspaper, and have a file that's available to the public at the courthouse, which lists your beneficiaries and your assets. So there's confidentiality with the trust. So there certainly are benefits, and if you think that it may benefit you, I'd urge you to sit down with your attorney and talk about whether that's the right thing to do. And it's not always. A lot of times a simple estate plan with a will and powers of attorney and things like we've talked about before is perfectly fine. It's adequate to meet those goals. But certainly trusts have their place, and they should be considered as part of an overall estate plan.
That initial consultation, in your case, would be free.
That's correct. Yeah.
And if somebody is interested in pursuing that further, learning more about trusts, what must they do?
Stop by the atrium, Suite 11, or call me at 724-465-5826, or go online to www.westernpalawyer.com.
He's Marshall Chriswell.
Thanks.
With us this morning. The installment is called Martial Law.